Okay, so good morning, everyone. Welcome to this webinar by Appleyard Lees for their innovation workshop on getting the most from your IP strategy. Just a couple of housekeeping points. Can you just make sure all of your microphones are on mute and cameras off? And if you have any questions, to put it in the chat box. And I'm now going to hand you over to Edward, and I hope you enjoy the session.
Just share my screen. Hopefully you can all see that now. Okay, so thank you all for joining, and thank you to One Nucleus for arranging the innovation workshops. Hopefully I will see you all at Genesis on Thursday. I'm going to give you a innovation workshop on getting the most from your IP strategy, and I will just introduce our team. Don't know if you can get rid of this bar. There we go. I am a senior associate at Appleyard Lees. It's a patent and trademark intellectual property law firm, and I work very closely with Barbara Fleck, who's the head of life sciences at Appleyard Lees, and the associate in our group, Claire Devine, and we'd obviously be more than happy to talk to you about any of your IP needs. But to get into the presentation today, I'm going to have 4 sections, just a very short section on patentability, and then IP strategy, how ownership relates to IP strategy, and how also freedom to operate relates to having a good IP strategy as well. So just very briefly on what is patentable. So as you may well be aware, patents are territorial, and different territories have different requirements with regards to what is and isn't patentable. And this is true in particular in the US and in Europe. And there are very particular requirements specifically around biotechnology and software. And obviously, for those of you who may be in the tech bio space, both of those can be very important things to consider when looking at territories which you want to file in and what the requirements may be in those territories. So, however, despite some of the restrictions that can be placed around software patenting and biotechnology patenting, it may be possible to overcome those restrictions based on claim wording. And therefore, it's always good to discuss inventions in these technical fields with patent attorneys ahead of time to identify the possible difficulties and the possibilities for patenting and some of the language that you may wish to include in your patent applications to ensure that you don't run into some of the restrictions that are there for these technical fields. So moving on to the main body of the talk, which is about IP strategy. The first thing to say is that it is never too early to start thinking about an IP strategy. IP strategy and the business strategy should really go hand in hand. They should be married up to each other and partnered such that they are integral to each other. Excuse me. An IP strategy should really be bespoke for every business, because every business has its own challenges, and this can be in technical field, what's patentable, but also in things such as the competitive space that you're working in, freedom to operate, etc. So establishing the goals that you're seeking to achieve as you move forward with your business plan can be very important to ensure that your IP strategy is linking into that and supporting it, such to provide as much value to the business as possible. So the first thing perhaps to consider is what is and isn't likely to be the subject for a patent application, and what things that may be possibly subject matter that could go in a patent application that you might actually be better off keeping as a trade secret. And it's important to define that as early as possible and ensure that for the subject matter that's going to end up in a patent application, as well as subject matter that you're going to keep as a trade secret, that is not disclosed to the public, and that the people within the company are aware of this as early as possible, and that the requirements for confidentiality around certain technical areas is maintained. So it's also an important first step to really consider what your key territories are and whether or not you can pursue that subject matter in patent applications in those particular territories. And if so, is there any particular aspects that need to be put in to support that into a patent application so that you don't run into any issues later down the line in particular national phase entries. It's also important to identify this as early as possible to ensure that you can have a cost-effective approach to entering those territories as well. Should you be going, for example, with a first filing in the UK and then a PCT and then entering the national phase, or would it be more beneficial to maybe just enter into, say, Europe and the US because that's all you're interested in from a claiming priority from your original GB filing, as it may be that that's more cost effective and more expeditious in terms of time than going through the PCT. So that's another consideration to think about. Also, as early as possible, think about freedom to operate. What are your competitors doing? How is that going to influence your needs with regards to possibly seeking licenses? Is there anything you can do to get around other people's patented technology? Which you can think about as early as possible before perhaps being locked into a particular path in terms of your products and development. So if there is third-party patent applications and patents that are out there, do you need to start considering filing third-party observations or oppositions against granted European patents, such that you can potentially knock out or prevent from ever being granted competitors' IP, which could be a problem to you? So, as I say, alternative approach to maybe taking on other people's patent applications and patents is to seek a license, preferably, obviously, an exclusive license for the key technology. This can be beneficial as it can actually improve your standing and attract more investment if you have an exclusive license to a key piece of IP. And one thing I should point out with regards to third-party observations and oppositions is that you may be able to file them at the EPO at the very least anonymously. So it might be that you can potentially seek to prevent people's patent applications from being granted or to knock out people's granted patents at the EPO without actually exposing yourself as the party trying to do that. So they can be quite powerful tools, at least in Europe. So an important consideration with regards to your IP strategy is when to file. So are you planning to disclose your invention? If you are planning to disclose your invention, then I would say that that is a very key point when you need to have a patent application on file. It may be that you want to hold off disclosing your invention even after you've filed a patent application because the patent application won't publish for 18 months. So you may be in a position where you can seek patent application and patent protection before anybody knows about the invention before it's published. But if you are going to disclose it yourself at a conference or putting a product on the market, then it is definitely the time to file a patent application, because once an invention is disclosed, you cannot file a patent application. It needs to be confidential and undisclosed to the public in order to obtain patent protection. Another important consideration is, do you have enough data in the patent application or potential patent application in order to support the breadth of the scope of claim that you're seeking? It can be that once you file your initial priority filing at, say, the UK IPO, that you will then have 12 months before you need to file either a PCT or in other territories, and you could potentially have more data to add to that patent application. But once you've filed your initial patent application, then that does sort of start the firing pistol, the starting pistol for when you need to ensure that you've got as much data as possible. So what data do you have now for your first filing? What data are you likely to have in the next 12 months is a very important consideration. And do you need a patent application with regards to negotiations for commercial partners and investors? It may be that you don't have the most amount of data, and that you know that you're going to need more data for your eventual patent application, but you might need to have something on file for those important negotiations with commercial partners and investors. So, and it may be what they require and what they're looking for if they are going to invest. So it may be that a first filing is necessary because you need to have that patent application on file to go into those negotiations. It's going to also be important to determine what your competitors are doing, what patent applications and patents they have, and whether or not you feel that you need to get something on file quickly because your competitors are filing lots of patent applications themselves, and it could be that you might find that there is prior art building up in a particular technical field that you want to get ahead of and get an as earlier filing priority date as you possibly can. So, as I said, one consideration is, do you need to keep the data confidential longer than 18 months? Is there a good reason why filing a patent application now and it going to publish in 18 months would be detrimental, and holding off would actually be more beneficial? And as I say, there's always the the thought of what licensing opportunities are there. If we have a patent application on file ourselves, is there the possibility that we might be able to get some cross-licensing such that it would put us in a good position when we're going to seek a license from a third party, because they might be interested in our IP as well as us being interested in their IP. So there are some important considerations to think about when you're considering when to file a patent application. So IP strategy in terms of competitors and your view on their IP and their view on your IP. So as I said, there's great power in having a pending patent application. And this paragraph I've written is probably familiar to anybody who may have already seen a Freedom to Operate report. This effectively is patent attorney speak for your competitor has a very broad claim. We don't think that it's allowable because it is incredibly broad, but we have to tell you that from what you've told us you intend to do, you're going to fall within the scope of this. And we can't tell you for sure that it's going to be limited by the patent office, but we expect that that's probably the case. And therefore, we're going to need to monitor it. So this means that you have always got a bit of a question mark when you have a pending application from a competitor with a very broad claim that may or may not be narrowed, and how much is it going to be narrowed throughout prosecution. So this is where having broad claims and broad pending claims can be very difficult if it's in one of your competitors' patent applications, but could be very beneficial potentially when competitors are looking at your patent applications, which is why I would say that it can be important to make use of divisional applications and in the US continuation applications to keep a certain gray area in the technical field, keep your competitors guessing. Use them to build defensive patents around your core technology. And this concept can sometimes be described as creating a patent thicket around core technologies, or sometimes that you're building layers of an onion around your core technology, because It can often be the case, particularly when you're looking at freedom to operate, that your competitor's patent application has been narrowed during prosecution and you now fall outside the scope of it. Great. But then it's just about to be granted and they'll file a divisional with a really broad claim and you're back to square one of guessing, where is this going to get narrowed? Are we going to fall within the scope of it? Are we not? So pending patent applications can actually be quite powerful to have a strong position within the technical field. So with regards to building a patent thicket, here's a bit of an example. Maybe have a core patent to bispecific therapeutic antibody, and then you've got all of these potential other claims that you could either have in your core patent application. It may be that you have your claims to the bispecific antibody, and in the same application, you may have some claims to the combination of therapies or medical uses. So they may be in the same patent application, but it may be that also that an examiner may feel that there's a lack of unity, say, between a claim to the formulation and the claim to the bispecific antibody itself. So it may be that you need to file a divisional or continuation to claim the formulation or a different modality or the dosage regime, so that you've got your core patent that maybe has some of these in, but then you maybe also have divisional applications that build upon that with different aspects which can be claimed to protect the space around your invention as much as possible. So it's important to think about what claims are we going to have in our core application, what are the most important ones to get granted, and then what are some of the other aspects which we maybe put in this application, perhaps knowing that we might get a unity objection and file a divisional application for some of those as well. And then if you do end up with a unity objection and you do need to file a divisional application, then it can be consulting with your patent attorney and for us to help our clients determine what maybe are the most important secondary or even tertiary aspects which you might want to protect in further applications. So there can be different sort of types of patents and claims that you might have, and it might depend upon the different type of biotechnology company that we're dealing with. So many may be dealing with developing single products which are directed to narrow indications. So more established companies, as I say on this slide, started with a particular product. So, for example, Genentech's first product was Protropin, which is a recombinant growth hormone indicated for certain types of dwarfism. So, and this is true for Amgen and Gilead, which also started with a particular product for a particular indication. So it may be that you're very product based and you need to consider your IP strategy from a product point of view, which may mean that your patent applications are directed towards more product claims, and that method claims and method of use claims may be important, but maybe more secondary. Or alternately, a lot of companies now may be focused on platform technology. And a great example of platforms which have actually then gone on to yield products is CRISPR. So there are obviously some quite well-known companies which are involved in the CRISPR space, like CRISPR Therapeutics, Ditis, and Intellia. So they all started in the commercialization of CRISPR technology and elements for performing CRISPR, which have now all gone on to start to protect products which are developed using that CRISPR technology. And here's a graph which demonstrates the impact on the share price for some of these companies. And you can see that CRISPR Therapeutics has some quite early announcements with regards to clinical trials for some of the products using CRISPR technology rather than just selling elements of CRISPR themselves. And you can see that the more that these companies have demonstrated that they are having products actually to treat certain indications, the higher that their share price has gone, and the more it has been beneficial for the company, the more information that's come out about their potential technology products. And you can see that Intelia and Aditis have started to have that same upwards curve once they themselves have started to release more information about their products and clinical trials related to them. So what does this sort of look like for these companies? Well, obviously gathering around auditing the IP within the company itself. So what is the core platform patent with regards to what CRISPR is, and then developing off of that core technology, that foundational IP with regards to CRISPR itself, assessing what there are the improvements for CRISPR components which these companies have patented, such as improved Cas9, sgRNA improvements, and then assessing what products can be used using the CRISPR technology itself. And then going forwards, what further developments there are to improve these products, what second generation indications are we going to be able to use. So why does IP matter for investment? So intellectual property is often used as to identify the suitability for investment targets. Does a company own a space within a technology field which it can prevent others from operating in? And that's demonstrated very clearly by what IP you have filed and is pending, and what IP you have patented. And as I say, it's an indication of the exclusivity of a technology company. It's often the biggest asset of a company. IP can actually go far beyond, say, what's in the warehouse in terms of what actually, if a company was to be sold, is the biggest and most important aspect of a company's assets. So it can be used to generate revenue for a company through licensing deals, and it can also increase in value beyond, say, the increase in if you owned a building or anything physical. IP doesn't have a cap on how much it can increase in value, depending on obviously the scope of protection and the interest in the field at large to license that IP from you. And just generally speaking, if you have good, strong patents which are of interest to others, then it can raise your profile, raise your credibility within the technical field. So one key aspect of IP that's very important to get right is ownership. And it's something I often say is the easiest thing to get wrong and sometimes the hardest thing to put right. So as an element of your IP strategy, determining ownership and ensuring that you have the correct approach to ownership and recording ownership is critical. So I'll give just two case studies, which are, this one is from a case of Edwards Life Sciences v. Cook Biotech. And another one is one that's not the case, but has actually cropped up in my general practice. So in the UK, an invention is owned by the inventor unless the inventor is employed to do to create that invention as part of their specific role. So an employee in the UK who is set up a particular task as part of their employment, that invention will automatically be transferred to the employer. If they then go away, if they're employed to create new CAR T cells and they go away and create a new fishing line, then that fishing line is theirs. But if they're employed to create new inventions relating to CAR T cells, then that would be owned by their employer. So with that in mind, in this case, there was a US provisional patent application that was filed, and it was filed in the name of 3 joint inventors as applicants: Obermiller, OC, and Thorpe. Now, in the US, it should be said that generally inventions are owned by the inventors until they're assigned. So in this instance, these 3 were the applicant as well as the inventors on this provisional patent application. A PCT application was filed claiming priority from the US provisional application, and this application was filed in the name of Cook Biotech as the applicant, not our 3 inventors that were the 3 applicants on the US provisional. Now, how did Cook derive the rights from these inventors and applicants? So Obermiller was an employee of Cook, had a contractual obligation to assign the rights to Cook. So because of this contractual obligation, even under US law, the rights were rightly Cook's, because Obermiller had this obligation to assign to Cook. OC and Thorpe were not employees of Cook Biotech, but the rights were assigned to Cook in September 2002, which was 21 months after the PCT application was filed. So in the UK, revocation proceedings were started, and it was held that the claim to priority, the original filing date of our US provisional application, was invalid because Cook didn't have the rights from OC and Thorpe at the time the PCT application was filed. Now, this meant that this priority date was deemed not to be valid. So it meant the effective date of all the claims was now our PCT filing date, not the date of the US provisional patent application. What would have been valid is if the PCT application had been filed in the name of Cook, because Cook derived the rights from Obermiller because he was an employee of Cook and had the contractual obligation. So that would have been fine to file it in the name of Cook, as well as OC and Thorpe. Now, and then you could have transferred the application entirely to the name of Cook Biotech when OC and Thorpe signed the assignment in September 2002. If they had done that, then the right to priority and to the US provisional patent application's filing date would have been valid. But because they didn't do that and they just filed in the name of Cook, it was deemed to be not valid because there was no proper chain of title and they didn't have all of the rights from the US provisional application. Now, in this instance, there was a disclosure after the filing date of the provisional application, but before the PCT filing date. The patent was therefore revoked for inventive step in light of the prior art published after the filing date of the priority application, this provisional US patent application, but before the PCT filing date. So ensuring that you have the rights to file as applicant and that you've derived those rights either by assignment or employment can be very important, because if it goes wrong and you lose your priority filing date, as happened in this case, then it can mean that your patent ends up being revoked. So in this instance, it was very detrimental to Cook not to have secured the rights to OC and Thorpe, those inventors, before they filed the PCT application, because even though the rights were assigned afterwards, it's not possible to retroactively create a chain of title. It has to be done effectively in sequence before the rights are before Cook filed the PCT as sole applicant themselves. So that's just an indication in this instance with regards to patents to either ensure that the rights are assigned before filing in the name of a company, or that the employees in your company are or have contractual obligations to assign to you, or that they are specifically set out in their employment contract the tasks which they are specifically been employed to do, such that there's no ambiguity with regards to who owns the invention. So this is a slightly different situation, and one that, as I say, cropped up just in practice. I received a phone call from a prospective client who had some queries with regard to ownership. So in this instance, an employee of company A invents a novel and inventive medical device, and they file a patent application for the concept behind this medical device. Company A, however, commissions company B to design the look of it, to make it look good, to make it saleable, to make, in an attractive product, and maybe ergonomically useful to use as well, and also to write the software for controlling the device. So company A has come up with the concept of this medical device, and they're commissioning company B to help them make that prototype, make it look good, make it functional in terms of the software. So in this instance, company A originally told company B that they would also use them to manufacture the device after they'd done the work on the prototyping, writing the software, creating the look. But then they discovered that actually a third company, company C, would be able to manufacture it at a much cheaper cost. And they didn't want to manufacture with company B anymore. The question, therefore, is who owns the rights to the original invention, who owns the design rights to the look of the device, and who owns the copyright in the software? Well, as we sort of covered, an employee who invents the concept of the device for company A would, by their employment, their rights would be transferred to company A. So I think we can be relatively safe in saying that provided it's a UK employee for a UK company, the rights would be owned by company A. Now, company A commissioned company B to create the design, and therefore design rights would subsist in the look of the design, and there would be copyright for the software. And company A, when I spoke to them, were very much of the opinion that they therefore owned the design rights and the copyright. And that's not by default how the law works. So registered design rights and copyright will subsist with company B, even though they were commissioned to do it by company A, unless there was a contractual obligation in the contract between company A and company B to assign the rights to company A upon completion of the project. And this is quite common and is in a lot of companies who do this kind of work. They will have an agreement that effectively, when you pay your final invoice for their work in creating the device and assisting you with the prototyping, that they will then assign it over to you as part of being commissioned to do the work. But that's not the case by default. And I asked them, you send me your contract, I will look at the contract and determine who owns the design rights and the copyright, to which I was informed that they didn't have a contract. So I had to tell them that company B, who had informed them that they weren't going to take the work to be manufactured by company C at a cut price cost, because it would be infringing their design rights, and copyright were entirely entitled to state that. So, moral of the story, at the very least, always have a contract with your third-party companies assisting you with anything along the lines of creating designs or copyright or in software. So, in terms of ownership, key things are create a proper chain of title, have assignment documents timely executed, ensure the inventors know their ongoing responsibilities to sign documents in relation to the inventions, because this can be very important later. Actually, in the US, they may need to sign a declaration and assignment document, confirmatory assignment document in the US. Make sure agreements with third parties have appropriate IP clauses, and consult with your IP provider when those contracts are being created. Agreements should provide clear definitions of who owns background and foreground IP, i.e. the IP that you're bringing to the table and IP that may be derived from collaborations with third parties. And make sure that IP is transferred from founders to the business. I say this because it means that would be an asset to the company. So that increases value to the company for IP to be in the name of the company rather than perhaps the original founders who may have filed their IP in their own names. And I also, as a small point, beware of issues with electronic signatures on documents such as assignment documents at the European Patent Office. I say this because they have a very, very high standard for electronic signatures. It has to be a qualified electronic signature, which is defined by a European regulation, and that can often require using registering yourself with, say, DocuSign or Adobe Sign, and that can be a very rigorous process in informing them of your details, such as copies of passports or other documentation, in order to then get an electronic signature devices, in some cases to generate an electronic token, which is a qualified electronic signature. So it's a very high bar that's expected at the EPO. And also there was a recent legal division case which was appealed, which actually called into question the entire validity of using electronic signatures at the EPO. So it's a matter that we hope to have some clarification on in the future. And in the meantime, I would strongly urge people to just pick up a pen and do it the old-fashioned way if an assignment or a document is going to be filed at the EPO, rather than just assuming that you can just use standard signature that you get generated from DocuSign, because that may not actually be the case. So just beware of electronic signatures at the EPO, and maybe just use handwritten old school versions for now, until we've got a little bit more clarification from them. So I'm just going to briefly touch on freedom to operate. So freedom to operate, as you may well be aware, is extremely important to determine what IP is owned by your competitors. It can be a bit of a myth that because you've now got a granted patent, that you can then make and use an invention within the UK. And unfortunately, you may have a patent granted for a certain invention. However, it may be possible that making and using it, even though you've got a granted patent for it, infringes other people's rights. So here's an example. You've got discovery that drug X can be used to treat arthritis. So you've now got your patent for drug X for use in the treatment of arthritis. Here's the scope of your claim. It's to this drug, and it's for the specific indication of treating arthritis. But drug X may well have been known, and there may be a patent that has a claim to drug X. So here you can see the green circle is the scope of a patent to drug X, and you are using drug X. It may be for a new indication. It may be for an indication that nobody has ever recognized or considered for this drug, and it may well be patentable because nobody has shown before that you can use this drug for this particular indication. But that doesn't mean that you get around the fact that there is a patent with a claim that is just to drug X. and that's it. So in order to sell your drug for treatment of arthritis, if this patent for drug X was in force, you would still need a license to the patent for drug X. So it's very important to determine what patents are in your technical field and work out whether or not you may need to seek a license, or if there is a potential workaround such that you fall outside of the scope of the granted patent. So how to avoid getting in trouble. So a granted patent will give you the right to prevent someone from using your invention. Term of a patent is generally 20 years, provided all the renewal fees are paid. There may be some extensions, but that's maybe for another seminar. Granted patent doesn't give you the right to work your invention. It is solely what's called a negative right. It stops you from it allows you to stop other people from using your invention. It doesn't allow you to start doing something. So, and it's the scope of the claims, obviously, that define what that invention is. So, will the commercial product or method or methods used in developing the product infringe third parties? So, you need to perform a search and assess the rights of those third parties. There can be very competitive technical fields out there. Certain bispecific antibodies are a particular very competitive space. So it's important to determine what third-party IP is there, and it will minimize the risks that you could end up receiving a notice that you potentially are infringing someone else's IP. So it can often be a requirement for investors, purchasers, licensors. It can secure market access, can produce income via royalty streams, and it can avoid legal disputes. So I would suggest that FDO analysis should be performed as early as possible. So identify competitors and third parties working in the same targets. Do they have broad patents in the field? Do your lead molecules fall within competitor and third party patents? And this is basically through your life cycle. Really, you need to think then about what formulations there may be which may infringe third parties, and then in the clinical final product, once you have that nailed down, are there any freedom to operate issues? It's good to know this at the discovery side on the left hand side, rather than only realizing at the right hand side when you have a final product that actually you need a license and that there may be some freedom to operate issues. So it's good to do it throughout, to keep coming back and considering freedom to operate at all of these stages, but to get into the mindset that freedom to operate is something to think about as early as possible. So as I say, it should be repeated and reviewed throughout product development. Should provide you with a clear position, and may even end up giving direction to the research, because it may be that you need to get around some granted patents. So it can actually lead to changes in the final product if you know early enough and can guide the research in light of the freedom to operate. So it is something to update as often as needed. So there are two ways of doing it in some regards. You can engage external counsel, and we will use a searcher and then provide a report to let you know what's pending, what could be a problem in the future, and what's granted and may be a problem right now. So it can, however, be done in some sense in maybe a more limited scale in-house. So there are free databases such as a SPASnet, Google Patents, PatentScope, etc., which you can look at. They're very intuitive. You can do keyword searching, you can search by jurisdiction, classifications. So if this can be a good way for companies to limit the costs associated with freedom to operate, to maybe do a first pass and then say, okay, well, we maybe don't have the budget to do a comprehensive freedom to operate search right now, but we've looked, we're concerned about this, this, and this. Please, can you give us some guidance on these patent applications or patents? So at the very least, I would recommend doing that. Freedom to operate can be expensive. Doing the searches, doing the reviews, it can lead to costs for external counsel. But at the very least, if a first pass can be done in-house and the most critical ones can be passed on to external counsel for an in-depth, thorough review, then that's at least something, and at least will provide some guidance and potentially provide investors with some comfort that you have looked into what the commercial freedom to operate is in your technical space. So this can be updated regularly. You can get a good picture as it evolves, because obviously an analysis is only a particular snapshot in time. And it's important to note, as I mentioned earlier, that a patent application is published after 18 months. So if we were to do a freedom to operate review today on a particular technical field, there may be patent applications which are relevant, which we wouldn't know about unless we update that review in at least 18 months' time, because patent applications will be publishing as we go along. But if something were to be filed today and we did an FTO today, we wouldn't actually see it for another 18 months. So it's important to just keep coming back, keep looking, monitor the pending applications as well. How is the scope changing? Are you now falling outside of the scope because of limitations that have been made? Is it something that you need to consider perhaps filing third-party observations for, as I say, could be anonymously, to guide an examiner who maybe hasn't found a critical piece of prior art that you're aware of and may be important in preventing this competitor from getting a granted patent. So performing freedom to operate and performing it semi-regularly is quite critical. So options to consider if the path is not clear. You may wish to consider whether you have any exemptions for infringement, BOLAR exemptions, for example. Are you going to launch a generic product which already has a patent? You may be able to perform certain experiments in order to get regulatory approval. Is it a new invention where you need to perform research using patented technology, but you're doing it for your own regulatory approval? You may have fall under the BOLAR type exemptions that are currently in the UK. Can you develop a workaround so that you're not falling within the scope? Is it potential to license or even cross-license if you have some IP that you think this competitor may be interested in, so that you can get good position in a licensing negotiation? As I say, consider validity, third-party observations, oppositions, and then maybe potentially reconsider redirecting the R&D. So in summary, it's never too early to think about the IP strategy. Get a good strategy in place. What are the key things you want to get out of your IP? Is it for investment? Do you need to IP to get that investment? So you may need to file earlier than maybe you would ideally want to, or do you want to hold off? Do you want to not file a patent application until you've hit certain R&D targets? You should consider this before, rather than maybe at a later date where maybe some advantages to maybe filing early have been missed. Consider FTO and align with product development, and I'd suggest consulting with your IP attorney regularly to help you with defining what IP you need, when you need it, why you need it, and what FTO issues there may be out there. And also just a nod to my trademark colleagues, registering product and company names as trademarks can be very important, because you don't want to build up goodwill in your brand, your identity, and then have others try to muscle in on your product names and company name, even though you've built up goodwill in your name. So do consider trademarks as well. And with that, we'll take any questions.
I believe there's one in the chat. Not sure if you can see that, Edward.
I'm not sure I can see that while I'm sharing my screen. Maybe I can. Aha, here we are. Found it. So for many Western companies, the US and Europe IP situation is more familiar, established. China is becoming increasingly important in terms of market size and licensing opportunities for Western companies. As such, what advice would you give to companies related to, one, what they need to think of IP-wise relating to China? How is the law different or the same? Key differences in what one can and cannot patent, and any common pitfalls companies make. So that's a very good point. And one thing to consider for China is that the Chinese Patent Office is much more strict when it comes to support. So, for example, you will always include some examples, particular examples in the patent application, just as, excuse me, some exemplary embodiments to your invention. And you will find in China, they are much stricter in trying to limit you down to what's in those exact examples. And it can be a bit of a struggle to get broader scope of protection. So for example, I have seen an issue whereby there were multiple different luminescent proteins that could have been used in this particular invention. One of those luminescent proteins was set out in detail in lots of different examples of different experiments to show that it worked within this invention. And then there was one experiment that said this luminescent protein is very equivalent to this other luminescent protein, but that other protein wasn't shown in all of these examples. Now, the Chinese Patent Office said, well, we'll only allow the luminescent protein within the invention for the one that you've shown in all of the examples, and they wouldn't even accept that you could. We had already shown that the other luminescent protein was equivalent in that one experiment, because we hadn't shown it in all of the different settings. So they can be very, very strict. So one thing, if you are very interested in China, make sure that you've got at least your key subject matter, maybe your key proteins, exemplified in the application as filed, because you may find yourself being very limited to that subject matter. And also, it is changing. They are getting slightly better. It is not great, but if you were in that situation and in Europe at the EPO, and the European examiner said, well, I don't think that this is supported, this other protein, because you haven't shown it in this experiment, and this experiment, unlike that one, you could then file post-filed evidence. So basically just do the experiments again for the other protein and say, well, look, it works. It does what we said it would do. And the European examiner will go, yep, no, fine. Generally speaking, will be much more willing to say, yep, okay, that makes sense. It works. In China, they are far less willing to accept post-filed evidence. So if it's not in the patent application as filed, you may well get an objection that the skilled person wouldn't have been minded that they'd have a reasonable expectation of success, even though you've shown it in post-filed evidence. If it's not in the patent application, you might run into trouble. So one of the key things for China, I would say, is as I say, ensure that your key sets of proteins, key sets of antibodies, you know, particular sequences for antisense oligonucleotides, whatever it may be, is exemplified in the patent application as filed, because you may find difficulties if they are not in China. So that's one key difference in terms of there's no grace period in China. So if there was a disclosure in the US, you may be able to file a patent application despite there being a disclosure, but you certainly won't get that in China. They have different requirements with regards to some biotech issues, but actually a lot of it is similar enough to Europe. They won't allow methods of treatment, but they wouldn't be allowed in Europe. You can get around that with more what we call further medical use language, drug X for use in the treatment of disease Y. So that's more similar to Europe than it is to the US and China. But yeah, depending on some of the key areas that you're working in, we could certainly have a more detailed discussion around that. Probably take up a little bit more time, as I think we've just hit 12:30. So I believe I have to stop. But please do get in touch if you want to discuss that and your specific requirements. I'm more than happy to talk that through with you.
Okay, so just to close it off, I want to thank Edward for the presentation, and I hope you all enjoyed it and had a great day.